Okay, good afternoon, everybody. We'll make a start because we've got so much to get through today. So nice to see you all. My name's Amy. I am an immigration and public law solicitor and a consultant at DG Legal, and I'm hosting the webinar today with Adam Pipe. He's here from No. 8 Chambers to offer this session today on Immigration Judicial Review. It's an introduction and an update, so hopefully useful to those who maybe are new to judicial review or have limited experience, but also it's going to be a great refresher for those of us who've been maybe doing it for a while or who haven't done it for a while but want to get back into it. Just a little bit of housekeeping before we get started. To let you know that we're in webinar mode today, which means that we can't see or hear you, but hopefully you've got no issues in seeing or hearing us. If you do have any issues during the course of the webinar, if you pop them in the chat box and let me know, I'll try and get back to you as soon as possible. Also, as I said, we've got quite a lot to get through for today, but we will try and allow some time for questions at the end. It may or may not be possible, just depending on how much we've got to get through, but we'll do our best. And to let you know that a copy of the slides and a link to the recording will be sent out to everybody tomorrow, so you'll receive that by email. So without further ado, I'll hand you over to Adam, and I hope you enjoy this session.
Thanks, Amy. That's fantastic. And it's really great to have so many people joining us today. I think at the last count, we were 940 people signed up, and there's hundreds of you who've come in live today. So thank you so much. Apologies if I sound a bit croaky today. It's back to school, colds and flu time. And also, as a passionate Welshman, I was shouting loudly at the rugby on Sunday night, so apologies to any Australians viewing today. But today we're going to cover Immigration Judicial Review. As Amy said, there's going to be both an introduction and an update. I don't know if you've ever watched an episode of The Simpsons. You can watch it with your 4-year-old and they can be laughing their heads off. And you can also be laughing at something totally different. And hopefully there's something for everybody at different levels, whether you're completely new to Immigration Judicial Review, you're a student learning about it, or you're a salty old hack who've been doing immigration law for 20 years. Hopefully there's something for everyone. What I've done, I've deliberately done very long slides. So there are actually 100 slides today, and there's probably enough in the slides for a full 3-hour seminar. But I want you to be able to have those slides as a resource from me to equip you to go forward in judicial review, whether it's as a refresher, whether you want to use the material in the slides for your letter of advice, for your PreAction Protocol, or even as part of your judicial review grounds. Those slides will hopefully be a resource for you, but we'll skip through them today because there is so much content to cover. As I've said, my name's Adam Pipe. I'm a barrister specialising in immigration, asylum and human rights law, and I'm based here in Birmingham. If you've seen any of my previous webinars, you'll know that I provide resources and updates by video, PDF, webinars and the like. So if you've got a phone, do grab your phone and scan the QR code on this slide now. You'll get the slides tomorrow. So don't worry if you miss it, and there's a link there. And at the very end of the webinar, I'll put this slide back up with the QR code. But there you'll get access to some free case law PDFs, recordings from my recent DG Legal webinars, upcoming events that I'm doing, YouTube videos and the like, lots of free resources for you there. So scan that QR code. You can also sign up and join my Telegram channel where I post regular updates, and also sign up to YouTube, Twitter, or is it called X these days? Who knows? But let's crack on. So first thing I want to do today when looking at Immigration Judicial Review is give you some helpful resources and guidance. So the first thing is the guidance for applying for judicial review in the Upper Tribunal in an immigration or asylum case. So the Upper Tribunal, what I'm going to call UTAC today, has provided guidance on applying for judicial review. Now, even if you're experienced, don't sort of put this aside, bookmark this, because it has links to the latest forms. It sets out links to the practice directions and also has details of the current fees for judicial review. In a minute, we're going to go through the practice direction for judicial review in the Upper Tribunal in UTAC. So here's a link to the practice direction. And then here's some links to some of the forms. These are the general forms, which include applying for judicial review, the acknowledgement of service, an application for anonymity. But more importantly, here are the list of the current forms, and they've been renumbered. So you may not be familiar now. They're much more simple. So UTAC 1 is the application. UTAC 2 is the statement of service. UTAC 3 is the acknowledgement of service, which the Secretary of State will respond and provide their summary grounds of defence. If you've got an urgent application, it's the UTAC 4 if you're providing it at the same time as your UTAC 1. If you're providing it later, it's your UTAC 5. You've got your application notices. You've got an application for oral reconsideration, UTAC 11. And if you're making an application to appeal to the Court of Appeal, your UTAC 14. So here's the key forms which you need to be aware of, and make sure as a firm, if you're doing this kind of work, you bookmark that work. What about fees then? So an initial application to UTAC for judicial review is £154. If permission is granted, don't forget to pay the fee. It's £770, otherwise your case will get struck out, and that's to go forward for a final hearing. If you're applying for urgent consideration at the same time as you're making your application, so you're submitting a UTAC 1 and a UTAC 4, there's no additional fee. But if later on you need urgent consideration and you submit your UTAC 5, it's £255. Where you're applying for appeal to the, for permission to appeal to the Court of Appeal, it's £100. Now, if permission is refused, you'll want to ask for oral reconsideration. That's £385. And if the judge grants permission, you'll then have to pay an additional £385 to make it up to the £770 to go forward for a full hearing. Notice there's no fee to give notice to withdraw. And there are different fees for application notices depending on whether or not the Secretary of State, the respondent, consents to the application. So those are the current fees as of September 2023. Now, you may have seen this. This is a recent update. So if you're a practitioner in this area, be aware that from the 1st of September 2023, if you're filing documents with the Upper Tribunal, and here's a bit of extra for you, this applies not just to judicial review, but also, it also applies to statutory appeals. You need to now use the CE file system. And actually, even if you're an unrepresented appellant or applicant, you can still use it. So there's guidance. I've put the practice direction link. I've put the link to the guidance, and I was emailed by a solicitor the other day asking, how do you register? So the bottom link is how you register. So if you run a firm that does Upper Tribunal work, either statutory appeals or judicial review, please register for CE file today, because that's the expectation from now on, and that's hot off the press. You may have to lodge a judicial review in the administrative court. So I've put here the links, and these are hyperlinked from my slides, for the forms and guidance, the policies and practice direction, the civil procedure rules, and all the guidance. So if you're in the administrative court, look at these links. And again, you may need to lodge in one of the administrative court offices. Here are the offices, the contact details, the telephone numbers if they have a telephone number. So there's the RCJ, Birmingham, where I am, then Leeds and Manchester, and of course the promised land of Wales. So England and Wales, here are the administrative court's addresses and phone numbers and contact details for you. So do again, make a note of those in your firm. One of the key documents that have aided me in preparation of this webinar is the Administrative Court Judicial Review Guidance 2023. And it's a couple of 100 pages long. It's effectively like a judicial review textbook. So actually, if you're a student, or if you're somebody training, or you want to get into judicial review, do download this PDF. What I do, if you ever want a hack, here's my hack today, use Speechify. Speechify is a PDF reader, and I use this to get Home Office PDF policy documents and long documents read to me. So on the bus home last night, I listened to the administrative court guidance at 2.5 times speed being read to me. But this guidance is fantastic and really good. Obviously, it applies to the administrative court, but most of the principles set out therein apply equally to upper tribunal judicial review, obviously making the appropriate amendments in terms of forms and procedure, etc. The Law Society has also produced a practice note on immigration judicial review. It's a couple of years old, but it's still really helpful in terms of professional duties. And that's something we're going to come back to in this webinar. And also in terms of process and procedure. You don't need to be a solicitor to access this. I've registered on the website, and you can access the full PDF. Again, really important, some really helpful stuff there. Now, again, some hot off the press news. Normally, if you're OISC, you can't do judicial review. But the OISC do have an accreditation called Judicial Review Case Management. So OISC advisors can register as part of the Judicial Review Case Management accreditation. But the OISC have recently changed in July of this year their practice note because of the definition of conducting litigation, because an OISC advisor can't conduct litigation. And this arises from a 2023 case called Baxter and Dobble. So it now means, look at the final paragraph on this slide, this means that the OISC will now consider any work undertaken on a case after proceedings have been issued at the upper tribunal as conducting litigation and therefore not authorized under the JRCM category. After a judicial review claim form has been served, OISC advisors will only be permitted to liaise with the clients and counsel. And again, these are advisors who are already authorized under judicial review case management, and they need to work with a barrister who has a conduct of litigation ticket. So do be aware of that if you're an OISC advisor, and I've put the link there where you can find the revised practice note from the OISC. Let's look at some practice and procedure then. What is judicial review? Well, I've set out, and again, some amazing stuff on the Public Law Project website, and you can also listen to some recordings of their CPD webinars on judicial review. But judicial review is a way of challenging the decisions, acts, and sometimes the failure to act of a public body because it's not acted lawfully. It is a court procedure brought in a branch of the High Court known as the Administrative Court, or in relation to certain types of case in the upper tribunal. And that's what we're largely dealing with. Look at the final paragraph. Public bodies, such as central and local government, have to obey the law in how they take decisions and act. Where they don't, they can be said to have acted unlawfully. The type of law governing the conduct of public bodies is known as public law. Public law principles ensure that public bodies discharge their legal duties, do not abuse their powers, and abuse of power is a key concept in JR, and act compatibly with the human rights of those affected by their actions. So what are the common types of claims we'll come across in immigration judicial review? Well, if your client has previously made an asylum case or a human rights case and makes a fresh application, and the Secretary of State refuses that claim, the Secretary of State will consider paragraph 353 of the immigration rules to see if it should treat it as a fresh claim, and only a fresh claim will be given a right of appeal if refused. If you're not given a right of appeal, you have to challenge by way of judicial review the fresh claim decision, and it's often concerned about whether the fresh material creates a realistic prospect of success. And I'm sure a lot of you are familiar with the key case WM-DRC from a long time ago, which sets out the fresh claim JR test. So fresh claims. What about cases that are certified as clearly unfounded? You may have made, say, a human rights case, an in-country partner case under the 10-year route, and the Secretary of State may certify it as clearly unfounded. That doesn't, again, the only right of appeal there is out of country. So the only option there is judicial review, and the Secretary of State on clearly unfounded is saying, look, this case is completely bound to fail. So it's not just the Secretary of State disagrees with it. It's worth looking at the Secretary of State's certification guidance there. They've got to show that it's completely devoid of merit. So you may be used to challenging certification cases. What about where there was a right of administrative review and that's been refused? So recent examples I've been involved in is, say, PBS cases. So partners of skilled workers I've recently had refused, perhaps because they failed to declare previous immigration issues and then been refused under the general grounds. Domestic violence cases may be familiar to people, where the Secretary of State doesn't accept the evidence shows that the marriage broke down during the initial period because of domestic violence. And often you'll question the Secretary of State's approach to that evidence, saying, well, they haven't properly applied the standard of proof. They've looked at different evidence in isolation. They've been too sort of hierarchical in the evidence they'll consider and not weighed up all of the evidence. And you'll challenge. One of the key cases there is UTAC from the Court of Appeal. My last DG webinar was on visit visa applications and challenging refusals. If you haven't watched that, I'd encourage you to do so. But you may get to the point where your client's been refused visit visas on multiple occasions. And it's always worth putting in a fresh application, plugging any gaps. And then you decide, well, now's the time to challenge by way of judicial review. But we'll come to that in a moment, because remember, judicial review is different to an appeal. You're not going to get the visa at the end of it. The most you're normally going to get is a reconsideration. What about refusals of naturalization? Often say on good character grounds. We'll come and look at that in a moment. And I know the next free DG webinar, I think Eric Fripp is doing a webinar on, particularly on naturalization refusals. What about sponsor license revocation? You may have clients who've had their sponsor license suspended, you've done your submissions and then they're revoked. Particularly, I've seen challenges, or I've had to do challenges recently on care homes or care agencies who seem to have been targeted by the respondent. Unlawful detention cases. What happens if your application, your client's application has been outstanding and there's delay by the Secretary of State that's unexplained and there's no sort of time scale for when we're going to get a decision? Before we went live today, Amy and I were discussing this, so this is an issue currently. But there's always the tension there of how long is an unreasonable delay and what is the prejudice to your client by the delay. Then you may have an NRM, a trafficking, a national referral mechanism, conclusive grounds refusal. Or maybe you're challenging the lawfulness of the Secretary of State's extant policy. So in recent years, we've seen lots of successful challenges on the no recourse to public funds policy. Before lodging a judicial review, you need to do a PreAction Protocol letter and send it to the Home Office. This is an extract from the civil procedure rules and the PreAction Protocol section, and it sets out what you need to include in your PreAction Protocol letter in terms of the date and detail of the decision, a clear summary of the facts, the legal basis of the claim, and what you're seeking. Now, there is a letter, an example letter at Annex A of the PreAction Protocol, but the Home Office have actually provided a template, which I think can be used for all cases, say for urgent cases. So again, have you and your firm bookmarked this template letter? Because that's an easy way then of completing the PreAction Protocol letter. And it's important that you comply with the PreAction Protocol, because if you don't, you'll be punished potentially in costs. And you give the Home Office 14 days to reply, because hopefully that will resolve, because JR involves costs at the end of things. So we want to give them a chance to settle the matter without having to issue judicial review proceedings. And even if it's an urgent case, can you comply with the PreAction Protocol as much as possible, even if you can't give the full 14 days? Often I'm instructed to draft JR grounds before the PreAction Protocol stage, and I think that's premature, because regularly, and I say this carefully, the Secretary of State will agree to reconsider. Now, the Secretary of State is inconsistent in when she'll reconsider cases, and sometimes when she stands up and fights cases, but often the PreAction Protocol can resolve matters. Judicial review is a remedy of last resort. There must be no alternative remedy. What's an alternative remedy? Well, it's an adequate means of redress. So just because there is some sort of remedy does not necessarily mean that it is adequate. I was trying to think of an example here, and I put in brackets HR appeal versus rules. What do I mean by that? Let's give an example. It's one that I had a case recently on, and so it's fresh in my mind. You make an application for ILR based on 10 years lawful residence. That's refused, saying you haven't got your 10 years unbroken residence, and your client still has extant leave. The Home Office, in their refusal letter, because they treat long residence claims as human rights claims, have given a right of appeal. But you think, well, hang about, my client's got leave to remain, so any appeal is going to be refused, because they'll say there's no breach of Article 8 because the client's not being removed. And what I want to challenge is the interpretation of Rule 276B and the gap in my lawful residence or whatever. There, it's arguable that there is not an alternative remedy because your human rights appeal doesn't allow you to attack the interpretation of 276B under the rules. I've put there in italics an extract from the Administrative Court Guide. Judicial review is a remedy of last resort. If there is another route by which the decision can be challenged, which provides an adequate remedy for the claimant, that alternative remedy should generally be used before applying for judicial review. Examples of alternative remedies include internal complaints procedures, review mechanisms. So, for example, when you're refused nationality, you will be given a right of review. So you need to exercise that first. If the court finds that you had an alternative remedy, generally you will be refused permission to apply for judicial review. Now, I've put a sentence at the bottom with sorry in brackets. A lot of people find administrative review frustrating and a bit of a damp squib that doesn't result in the decision getting overturned. So I sometimes get asked, oh, do we need to go through administrative review? Can we go straight to judicial review? Well, the answer is no, you can't go straight to judicial review, because administrative review is an alternative remedy that must be pursued first. And then time for judicial review will run from the date of the administrative review decision. So for the last decade nearly, the Upper Tribunals has been handling the majority of immigration judicial reviews. I put the link there to the Lord Chief's practice direction. But a decision under the Immigration Act or any instrument having effect, whether wholly or partly, and an enactment within the Immigration Act or otherwise relating to leave to enter or remain in the UK, that'll be in UTAC, or a decision of the Immigration and Asylum Chamber of the First Tier Tribunal where there's no appeal, any challenge there will be in UTAC. But there are some cases that remain in the administrative court. So what cases should you lodge in the administrative court? If you're challenging the validity of the immigration rules. So if you're arguing, say, the adult dependent rules themselves are inherently unlawful, like was argued in Britsits, that would be a JR in the administrative court. Unlawful detention. Now, we're not talking about removal there, unlawful detention. But the administrative court in a number of cases have told people off where they've sort of tagged on an unlawful detention claim just to get their claim in the administrative court. Sponsor license cases, they're in the administrative court. Refusals of British citizenship, administrative court. Decisions to refuse asylum seeker support, challenging a decision of UTAC itself or SIAC, or whether you're looking for a declaration of incompatibility, or there's national security certification, or trafficking claims. Trafficking claims are lodged in the administrative court. The Upper Tribunal's jurisdiction comes from Section 15 of the Tribunals, Courts and Enforcement Act, and it has the power, the Upper Tribunal, to grant the same orders as the High Court, so mandatory, prohibiting orders, quashing orders, declarations or injunctions, and relief has the same effect. But as we're going to see in a minute, Section 16 of the Tribunal, Courts and Enforcement Act provides that, and 31(2)(a) of the Senior Courts Act applies. So where it's considered that the outcome would have not been substantially different, even if the conduct complained of had not occurred, you're not going to get the relief you'd sought. So just be aware of that in terms of relief. I've highlighted, and you can go back in your own time and look at this because I've got my eye on the clock, some extracts from the procedure rules. You're aware of the procedure rules. So 28(2), you've got to make your application promptly, no later than 3 months. Within 1 month, if it's a decision challenging something from the first tier tribunal. Remember, what is the outcome you're seeking? You need to set that out in your judicial review application. What relief are you seeking? And then you need to set out your facts and grounds. If you instruct counsel, the document you'll get back is a statement of facts and grounds. If you need to apply to extend time, 28(7) sets out what you need to do. And it'll be your responsibility to serve a copy of your application on the respondent, so the Secretary of State and any interested party. And you've got to provide the Upper Tribunal with a statement of how you've done that, a statement of service. The Secretary of State then has got 21 days to provide an acknowledgement of service in which she will provide her summary grounds of defence. And she may at that point concede, and you may get a consent order agreeing to reconsider and hopefully paying your costs, which should happen in those circumstances. But if she fights on, the decision will then go before a judge for a decision on the papers, either granting permission or refusing permission. And you can, if permission is refused, apply for the decision to be reconsidered at an oral hearing, unless the Upper Tribunal certifies the case as totally without merit. If that is the case, you can only appeal to the Court of Appeal. We'll come back to that briefly later. If you're applying for oral reconsideration, that must be done within 9 days. And if you're going to rely on any additional grounds, you need to ask for the permission from the Upper Tribunal. This is the practice direction then. So Section 4 sets out what you need to provide. Any written evidence on which you rely. Remember, in judicial review, it's the evidence that was before the decision maker. Often I get new evidence submitted with the pre-action letter. That's not going to be considered as part, save exceptional circumstances, as part of the judicial review. It's a review of the evidence that was before the decision maker. Copies of any relevant statutory material and a list of essential reading in advance. You've got to file 2 copies of the bundle. Then here's what you need to provide if you're asking for urgent consideration. And if you're seeking an interim injunction, so say to stop removal, or an interim injunction to stop us, well, in the administrative court, maybe to stop a sponsor license being revoked, you need to provide a draft order and the grounds for the injunction. Again, if you're challenging removal, there are special requirements, and be aware at Section 15 of the practice direction what you need to provide in terms of challenging removal. So how do you apply to UTAC? Well, here's a part of the UTAC guidance, is the link to the UTAC 1 form, and reminding us that we need to use e-filing and that we need to file it within or no later than 3 months after the date of decision. I've set out my own sort of summary of the process. I've pretty much covered this already. So a 2-stage process: permission first, then if permission grants, go to a substantive hearing. Submit your application form with a statement of facts on grounds, provide your evidence, statutory material, essential documents, and don't forget your duty of candor. We're going to come to this. This is so important, and you could find yourself reported to your regulator if you don't comply with your duty of candor. So if they say a previous negative determination, you need to put that in your JR bundle. Put in your 2 copies, serve it on the Home Office, show the Upper Tribunal you've served it. You'll get the acknowledgement of service within 21 days. You get a permission decision on the papers. Permission decisions can be ordered in for an oral hearing in rare cases. If permission is granted, proceed to pay the full hearing fee. Hopefully, again, at that stage, you would get a consent order and the Secretary of State will agree to reconsider. If not, the Home Office will provide detailed grounds of defence in 35 days. If permission is refused, you can ask for oral reconsideration, as we've said, unless it's certified as totally without merit. The full hearing and skeleton argument needs to be done 21 days before the full hearing. And the applicant will need to file a paginated and indexed bundle of all relevant documents. It's not just your documents, it's the whole documents. It's an agreed bundle. You'll get a judgment then with the order. Costs will summarily be assessed and the tribunal will deal with permission to appeal. That's a broad overview. And I said, you've got to ask for what relief you're seeking. So what's the end game? What are you after? Well, here are the orders that can be made. So let's think about it. This is section 15 of the Tribunal Courts and Enforcement Act, a mandatory order. So you're asking for the Secretary of State to be ordered to do something. Now, as we're going to see, it'll be very, very rare that you'll get a mandatory order ordering that the visit visa will be issued. So that's something to be borne in mind. A prohibiting order to stop the Secretary of State doing something. A quashing order to set aside the decision. A declaration which sets out the correct legal position. An injunction which again prohibits the Secretary of State from doing something. And again, as I've highlighted, section 31 of the Senior Courts Act applies. So again, you're not going to get relief if it appears to the court that it'd be highly likely that the outcome wouldn't have been different if the conduct complained of had not occurred, unless there's exceptional public interest. We've talked a bit about timeliness. So you're not going to write to lodge JR anytime within the 3 months. You've got to do it promptly and in any event within 3 months. So you could have permission refused if you've lodged within 3 months, but the judge does not think you've done it promptly. Now, the administrative court guidance says this: where the claim challenges a decision, the time limit begins to run from the date of decision to be the challenge was made, not the date when the claimant was informed about the decision. And there's been some debate about this, because in immigration cases, often the Secretary of State may not make you known of the decision until much later. So actually there's a helpful comment by the House of Lords in the Anafrajeva case. House of Lords said this: the arguments for the Home Secretary ignore fundamental principles of our law. Notice of a decision is required before it can have the character of a determination with legal effect, because the individual concerned must be in a position to challenge the decision in the courts if he or she wishes to do so. This is not a technical rule. It is simply an application of the right of access to justice. That is a fundamental and constitutional principle of our legal system. So that's a helpful quote, particularly when the Secretary of State may have a decision but not notify you of it till some time later. What you'll often find is permission refused where a claim has become academic. What do I mean by a claim has become academic? Well, where there's no longer a dispute between the parties. So where the Secretary of State, often this is the thing, the Secretary of State will agree either in response to the pre-action letter or in the acknowledgement of service to reconsider the case. That then would render the case academic and permission is likely to be refused. What should happen in those circumstances, you should have a consent order getting your costs back. Academic JRs will only go forward where there's an issue of public law and there's a good reason in the public interest. So where there's a sort of really important point of public law that affects other cases, that's when they'll carry on with academic cases. That comes from a case of Salim from 99. But look at this from the administrative court guidance, and I've actually cut and pasted the footnotes as well. Where a claim is academic, i.e. there is no longer a case to be decided which will directly affect the rights and obligations of the party to the claim, it will generally be not appropriate to bring judicial review proceedings. An example is the situation where the defendant has agreed to reconsider the decision challenged. So the other day, I was instructed to do JR grounds in a visit visa refusal. The Secretary of State hadn't replied to the PAP letter, and she kept asking for more time. But our problem was our 3-month deadline was coming up. So I did the JR grounds, and I think it was the same day as we lodged the JR grounds, the Secretary of State responded to the pre-action letter saying, oh yes, we will reconsider this. My advice to the solicitors then was, well, we need to withdraw the JR or sort out a consent order, bringing the JR to the end if it's already been issued, because we've got the remedy we sought. The solicitors came back to me, and this is no criticism of them, saying, well, hang about, Adam, don't we want to fight on to get the judge to order them to issue the visa? Well, no, because the most you'll normally get is a reconsideration. And a lot of this is about managing clients' expectations in judicial review, which is different to an appeal. So the agreement to reconsider equals the remedy we would have got if and in a successful JR. So the claim is now academic. And as I said, the court will not get involved in academic claims, save sort of exceptional public importance cases. Let's look at some legal issues in relation to judicial review in the 20 or so minutes we've got left. And thank you for everybody for bearing with me, lots to cover. Let's start at the basics then. Grounds for judicial review. Often, if you ask a law student, what are the grounds for judicial review? You'll get this threefold thing: illegality, procedural unfairness, and irrationality. I'm very close geographically to Wednesbury. Jeremy Clarkson didn't like Wednesbury. Well, the Wednesbury case, it talks about irrationality, that the decision is so unreasonable that no reasonable person could have made it. And this threefold distinction, illegality, procedural unfairness, and irrationality, comes from the CCSU case from 1984. But these groupings, Michael Fordham says, and I'm quoting here from the Judicial Review Handbook from Mr. Justice Fordham, these groupings are neither exhaustive nor mutually exclusive. And I've put there in my slides a quote from the Public Law Project looking at irrationality, but also looking at the test of proportionality that applies in human rights cases, which we'll look at. What I did, I got Fordham out and I went through his chapter divisions on what he says are public law wrongs justifying the court's intervention. And this gives you a sense of the scope of JR. So a decision may be ultra vires, outside the powers. There may be a jurisdictional error. There may be an error of law, a material error of fact. The Secretary of State may have fettered her consideration, may have acted in bad faith. What about substantive unfairness, or taking into account irrelevant matters, or proportionality, or bias? All these different aspects of public law errors. And actually, the Judicial Review Handbook is excellent in that respect and gives sort of case references. Now, if you're watching and you're a student, don't go out and buy, sorry to Sir Michael Fordham if you're watching, Sir Michael, don't go out and buy his Judicial Review Handbook. It's very expensive. I have put the Amazon link, but it's not a textbook as such for students. It's a practitioner text. But if you're involved in drafting regular JR grounds, this is very helpful and up to date and referred to by the judiciary. What about if human rights are in play? Well, I've put on the slide there some quotes from the case of Balajagari. Balajagari was the case of the Tier 1 general migrants who've been refused indefinite leave to remain because of dishonesty allegations in relation to their tax affairs. Now, Article 8 was engaged in those cases. It was held in Balajagari. And because Article 8 was engaged in a judicial review, proportionality then has to be determined in the judicial review by the court or tribunal. So that meant that the court would have to see if the dishonesty had been proved in their assessment of proportionality. So there's a different approach when it comes to judicial review and human rights cases. But that doesn't mean that all allegations of dishonesty will have to be proved in a JR. So in this case, Ashra Fuzzaman, forgive me, which was an entry clearance challenge on a 327A dishonesty allegation from 2022, the Upper Tribunal said this: the issue of dishonesty in a judicial review challenging a decision taken under paragraph 327A of the immigration rules is not one of precedent fact. In a judicial review challenge to the jurisdiction of the tribunal to determine an issue of dishonesty for itself arising from a decision taken under the general grounds of refusal in the immigration rules is dependent on the engagement of an ECHR right. So unless human rights is engaged, the tribunal will not determine the dishonesty allegation for itself. And there's a distinguishing between cases where human rights are engaged and not, and that is set out here. And it was accepted in this case that Article 8 was not engaged, so it was normal judicial review principles that applied. I just want to give you an example in practice of a fairness challenge, because often things will be challenged on procedural fairness grounds or rationality, and this concerns the points-based system. So this is a case called Taj from the Court of Appeal in 2021, Lord Justice Green. It follows the student case of Pathan, where Pathan hadn't been notified that his cause had been revoked, and that had gone to the Supreme Court. This was a case about a tier 1 entrepreneur whose business had found not to be genuine following an interview and a site visit. And Lord Justice Green in this case sets out the principles of fairness. So if you're doing a challenge based on fairness, particularly in a points-based case, have a look at this. So the Doody principles, Doody's the leading case from the House of Lords on fairness. Those principles apply to PBS, but the manner of their application will be fact and context specific. If you're ever challenging on the basis of fairness, you've got to apply it to the facts because it is dependent on the facts. There is a public interest behind having a requirement of procedural fairness, which is important, and that's set out here. If you are challenging by way of procedural fairness, you don't have to show that it would have made a material difference. So there is an absence of a pointlessness test that's set out here. Procedural fairness can be on an individual case, an operational failing, or it can represent an administrative failing, a systemic failing. And procedural fairness is a standalone obligation. It doesn't have to be linked to a substantive challenge. And administrative inconvenience and cost don't provide a justification for the Secretary of State to act in a procedurally unfair manner. In this case, Lord Justice Green held there wasn't a duty to put an applicant under the PBS on notice of general concerns, and there wasn't a specific duty in this case to put him on notice about concerns in relation to his truthfulness. Lord Justice Green, and that's why I've picked out this case as an example, then goes on to review rationality and criticises the test applied by the Upper Tribunal. The Upper Tribunal applied the Wensbury rationality test like this. Look at the italics in paragraph 80, that it has to be so outrageous in defiance of logic or accepted moral standards so that no sensible person who'd applied his mind to the question could have arrived at it. And Lord Justice Green said that sets the hurdle too high. And he says at paragraph 81, the modern articulation of rationality is somewhat less subjective and more prosaic and focuses upon whether the decision maker took into account irrelevant considerations, ignored a relevant consideration, whether the judge wrongly construed a key fact. If such an error is identified, the decision will be quashed. And only if there's no one of those errors, they go on to look at whether the decision is such that no reasonable decision maker could have made it. And the court will examine what margin of discretion to give the decision maker. Where a decision is highly political, in a judicial review, they'll give a wide margin of discretion. Where it's not a political, it's a sort of micro decision, as in this case, they'll give a far more smaller margin of discretion. And if there is a material error, there's no reason why the court should not quash the decision. But in general, because the PBS system has been held to be a fair and rational system, rationality is quite a high challenge. Now, I've said this a couple of times today. The evidence is the evidence before the decision maker. There is a presumption against what's called a rolling review. Now, this case was slightly different because there had been further decisions on what leave to give somebody on a trafficking basis. And the tribunal did allow the subsequent decision to be looked at and further evidence to be looked at. But in general, it's the evidence that was before the decision maker. And in this case, FT, the Upper Tribunal, went back to a case called Karupan. And we're going to look at Karupan now. I'm not going to go into it in detail. This is one for the practitioners. But this is a case that looks at supplementary decision letters. And Lord Justice Underhill, earlier in the judgment, not in the bit I've cited, looks at the different types of supplemental decision letters that there are. Some are just providing a few extra reasons. Some are a completely new decision and how the court should treat them. But he says this: I think it best to start with my conclusion before addressing the counter arguments. In my view, where in judicial review proceedings, a court or tribunal holds that the decision originally challenged in those proceedings is unlawful, it is open to consider whether a fresh decision to the same effect made subsequent to the commencement of proceedings is valid for the purposes of deciding whether to order the original decision to be retaken. So if the original decision is unlawful, but they've now provided a lawful subsequent decision, you're not going to get the relief you seek. So you're going to need to, perhaps in your skeleton arguments, engage with that subsequent decision to show why you should still get the relief you seek. But if there's been a supplemental decision by the Secretary of State, look at the Karupan decision. A couple of times we've already mentioned totally without merit certifications, which stops you orally renewing and means you have to go to the Court of Appeal. Two cases to help you with that. Grace from 2014 from Lord Justice Maurice Kay. Just because a case has been refused permission doesn't automatically mean it should be certified as totally without merit. It's got to be one that's truly bound to fail. And that was picked up by Lord Justice Underhill in the Wasif case in 2016. And there's a helpful summary of Grace and the approach. He says this: at the risk of spelling out the obvious, judges should certainly not certify applications as TWM as the automatic consequences of refusing permission. Previously, there was a sort of, it was in vogue. We got quite a few totally without merit certificates. I don't think we see so many of them at the moment, but I could be wrong about that. But certainly if you're faced with a totally without merit certificate, use Grace and Wasif if you're going to try and challenge that to the Court of Appeal. Again, don't get your application for JR struck out. There's powers to automatically strike out and discretionary strike out in Rule 7 and 8 of the procedure rules. This case of SN from Mr. Justice McCluskey, when he was president, sets out the principles and what you need to address if you're making an application to reinstate a struck out claim. So be aware of that and be aware of making sure you comply with any orders and the practice direction, etc. This is a slide I put up in my Visit Visa webinar. And hopefully you already know what I'm going to say because it's come out throughout this webinar, that JR is a limited remedy. In the majority of decision, what you'll get is a quashing, but not a granting of the visa. So in most visit visa cases, the decision may be quashed, but then the Secretary of State, all you get is a reconsideration, which may well lead to another refusal. And you may JR again, which may lead to another refusal, and that is not uncommon. So I think clients need to be aware of the limits of judicial review as a remedy. In Sultana, in relation to mandatory orders, Mr. Justice McCluskey held this is the head note. The remedy of a mandatory order is rarely granted It is appropriate only in cases where it is clear to the court that the respondent is legally obliged to take a certain course of action, normally involving the conferral of some benefit or advantage on the challenging party, with no choice or discretion. Where it's a discretionary matter, it's going to go back for reconsideration. Remember, costs are at risk. Costs, if you get refused permission at the AOS stage, it's the costs of the AOS at the permission stage, or full costs at a substantive hearing, and we'll come to that in a moment. And there's that sense that there can be a bit of a merry-go-round, because if there is a consent order, even if the Secretary of State doesn't comply with the consent order, the remedy for non-compliance with the consent order is not contempt proceedings, but actually a fresh judicial review. See the case of MMK. Now, in the last 10 minutes, very important, keeping you out of the doghouse. Now, I may be making light there of something that's hugely serious. I've set out here some extracts and the numbers, the footnote numbers from the administrative court guidance, but the Hamid jurisdiction is where representatives abuse the court, especially in terms of urgent removal cases. And what they'll do is send a letter inviting them, the representatives, to show cause why they shouldn't be referred to the relevant professional regulator. The court on the response, and I've had to be involved in some of these responses, may then convene a hearing, and they may then either refer you to your professional regulator or order wasted costs, or both. This is the case of Hamid. Please be aware of it. And one of the things they keep emphasizing is the duty of candor, and that if there are further events that render a case academic, you need to take immediate action in letting the court know, rather than carry on your urgent JR. Case of Mahmood. Again, the Upper Tribunal has said, well, we'll exercise the Hamid jurisdiction like the administrative court, and we'll also consider making wasted costs orders against representatives. And again, we've seen some recent judgments from the Court of Appeal where they've convened some of these Hamid cases, Hamid hearings in urgent removal cases such as SB Afghanistan, and in 2021 DVP. And this emphasizes the duty of candor, and also in urgent cases to try and give as much notice to the respondent as possible. Please, please, please read this. And I don't want to stop you fighting your client's cases. Where you've got a proper case that needs to be challenged, do it, but comply with your duty of candor, and just tread very carefully so you don't find yourself in one of these Hamid hearings. So the duty of candor, I've said it a number of times. You've got a duty to draw information to the court that actually undermines your case. So look at 15.1.4 of the Administrative Court Guidance. The duty of candor may also require the party in its statements of case to identify and explain the significance of information and or documents adverse to that party's case. So don't hide previous refusals, previous determinations. Put them in the judicial review bundle. And it applies at all stages of proceedings. Interestingly, against the Secretary of State, the Secretary of State has a duty of candor, even in their responses to the pre-action letter and the like. And there was a recent case in 2022 called HM, with the divisional court, including Mr. Justice Lane, held this in terms of the duty of candor applying to the Secretary of State at this early stage where they're responding to pre-action letters. And there's in a age assessment JR, I think this is Mr. Ockleton, held that the duty of candor may require somebody to disclose clients' social media communications, which is relevant to their age. And they may require a disclosure statement from the applicant's solicitor. So be aware of the duty of candor, and Mr. Ockleton sets it out here, so I've got that in your notes of the extent of the duty of candor. And equally, the Upper Tribunals also impose that upon the Secretary of State. Just a couple of final things and then we'll close. There's only 5 minutes left. Quashing orders, consent and reconsideration. Often when you settle a case, what your client will be concerned about is making sure their 3C leave is protected. Akinola considered this. The context was a late application of notice to appeal to the first tier tribunal. And the main thing held in the case was your 3C is revived from the date you put your late notice in, if time is extended. But they also considered the impact of when a decision is quashed, when a decision is withdrawn, and when a decision is reconsidered. When a decision is quashed, it is as if it had never been taken. So there's uninterrupted 3C leave. When a decision is withdrawn by the Secretary of State, 3C leave is only revived from the date of the withdrawal, and there will be a gap in the appellant's leave, but the Home Office guidance says they shouldn't be prejudiced by this gap. But if the decision is reconsidered, that has no impact on 3C leave. So your client, if they're unlawful, their leave will not be revived by a reconsideration. So this should make you think when you're settling JRs of what you want to have in your consent order. You want to try and get it quashed or at least withdrawn and not just a mere reconsideration. Here is the link for withdrawal and reconsideration and the quotes from Akinola. Just some final points. Evicting the cuckoo. This is about, and I'm sure Eric Fripp will cover this in his webinar, but in a decision to refuse naturalization on good character grounds, this was somebody who'd been accused of war crimes. It can only be challenged on irrationality grounds and not on proportionality. And Mr. Justice Mostyn, just before he retired, talked about the creep of proportionality like a cuckoo coming into the nest. So in less flowery language, there's the case of a min from the Court of Appeal. Because it's a discretionary evaluation, it's standard public law principles in terms of irrationality or some other public law error. It is not a proportionality challenge in relation to good character refusal. So there are some recent JRs in relation to nationality. You may deal with age assessment JRs. I've helpfully set out some principles. The principles I've drawn from Upper Tribunal Judge Grubb's summary in AS. So actually age is an assessment of fact for the court. That's from the London Borough of Croydon case A. There's no burden of proof. They'll assess all the evidence on the balance of probabilities. That's the CJ case. What about the court's general approach? Which evidence will it give weight? Which evidence will it won't give weight, such as physical appearance? That's AM and Solihull MBC. What about, does the age assessment comply with Merton principles and the minimum standards for age assessment? Have a look at the Merton case and AS Croydon. And what's the role of the benefit of the doubt? That's set out in A and London Borough of Croydon, and also WK and Kent and the CJ and Cardiff case. As I say, this summary is set out from AS, a decision in 2017, where Upper Tribunal Judge Grubb does a beautiful job of setting out those principles if you're involved in an age assessment. Costs, very quickly, because I've got about a minute left. Generally, the Secretary of State, if you get refused permission, will get her costs of writing the acknowledgement of service. You can separately challenge those costs. If you renew to an oral hearing, the Secretary of State, even if permission is refused, doesn't get the cost of instructing counsel to attend the oral hearing. Or what will be done is they'll affirm the order of the costs and the acknowledgement of service. That's the Mount Cook principle. But there are exceptional circumstances where they could order costs at the oral hearing. So have a look at this slide. At the full hearing, don't forget to file a cost schedule, because if you win, you'll get your costs. If you lose, the Home Office will get their costs, and they will be summarily assessed at the hearing. And please, 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 and I hope a lot of you have, there are still hundreds of you on, so this is good. If you lose, you'll have to pay the Secretary of State's costs. Now, this is a guesstimate, but I guesstimate they could be 5 to 10 grand. It's worth informing clients. And remember that a litigation debt owed to the Home Office is a general ground for refusal. So it'll affect future applications if you owe litigation debt. So just in JR, be aware of the cost implications. You can, if the Home Office really mess you about, apply for indemnity costs. And they messed about poor Mr. Butt. He had to do 6 JRs in his tier 1 entrepreneur. And eventually he did get indemnity costs where things are resolved in the receiving party's favor. It's much more beneficial assessment of costs. Because of time, I'm not going to go through that, but if you're looking for indemnity costs, that is all there. One final slide, and that's challenging policies by way of judicial review. If you're challenging a Home Office policy, following the Supreme Court in BF Eritrea and A in 2021, the test is now the Gillick test, that a policy must not direct officials to act in a way which is contrary to their legal obligations. It shouldn't sanction, positively approve, or encourage unlawful conduct, which is a higher test than that set out in the JCWI case, which was disapproved of in this decision. So it's a higher test in order to challenge the lawfulness of policies, but some cases have been successful, including the recent challenge to the no recourse to public funds, applying the higher test in BF Eritrea and A from 2021 in the Supreme Court. I'm sorry for going 1 minute over, which probably means we can't do questions. I'll leave my contact details up on the screen so you can get that QR code. You can connect on LinkedIn, YouTube, Twitter, or X, and you can subscribe to the Telegram channel. But I'll hand over to Amy. Thank you so much for putting up with me for an hour. I hope that's been helpful. Thanks, Amy.
Wow, Adam, thank you so much for that webinar. As a practitioner, that was just so useful for me as a refresher, and I'm sure to everybody else as well. And these slides are just such an incredible resource. So as Adam said, make sure you save them. You know, that it's really going to be so useful to refer back to, and having all those links in one place. So huge thanks, Adam. We're really grateful. Just to remind everybody as well, a copy of the slides and a link to access the recording will be circulated to everybody tomorrow morning. And following this session, you will receive an email just asking for some feedback. As always, we'd be really grateful for any feedback that you can provide. And finally, just to mention, as Adam referred to earlier, that our next free webinar on immigration judicial review is with Eric Fripp and Amy Childs of the 36 group. That's on Tuesday, the 3rd of October. And that's on judicial review in relation to the refusal of naturalisation on good character grounds. So join us if you can for that. The links to sign up for it, as always, are on our website. And I hope everyone's had an enjoyable time, and I hope you have a great afternoon. Thanks very much for joining us.
Thanks, everyone.